and there's about 50 wasps crawling across the...
Please make that plain, or issue an inquiry to do so. And the Attorney General last week wrote to us saying that he would not be meaning. So we haven't taken the step. We have. Oversight of the New Zealand Defence Force and the SAS operations overseas, and consideration of the deaths of civilians. This has been considered in other jurisdictions, including in the United Kingdom and in Europe, and so we consider these are important issues that the High Court should be providing its oversight over these proceedings to make sure that the inquiry is set on the right track.
So can you explain exactly what you want them to roll on, what you're wanting out of this?
Yes. We want it to be clear that this inquiry into the events of Operation Burnham is fulfilling New Zealand's right to life obligations towards the civilians who died, towards the 6 civilians who died.
So, to simplify, would you compare it to a coroner holding an inquest and not hearing from the families?
Yes,
involved?
I would.
So, why do you think that's not happening?
So, we've been thinking and racking our minds about why are we not on the right track here? Why are we off course, in our view, in our submission? And it seems as though what has happened is that this inquiry has skewed. And the skewing is, we say that the victims of Operation Burnham are our clients, are the villagers in Kakurada and Nayak. However, the way this inquiry has been operating is it's as though the NZDF are the victims. They're the victims of allegations that have been made in the book, and that they need to be able to defend themselves and their public reputation against those allegations. So we say that the real victims are our clients, and that's where our focus needs to be, about what happened to them and to get to the truth of what happened to them. And if the focus is there, then other important procedural matters will follow, including the right of access to information and disclosure of information. You know, we've had a lot of experience in cases that require classified information or closed material. It's not new to us. And in those cases, you are able to have mechanisms where the amount of information that's not disclosed should be kept at the bare minimum. How the legal system is set up is that it's open justice, it's transparent, but in certain circumstances, if there's classified information, you can have procedures to manage that information. But there need to be clear procedures, and then if people have an interest, that they can have summaries or special advocates and so on. We're not even adopting those measures, which are actually very controversial measures. Instead, what's happening is that the starting point is a closed process rather than an open process with some closed aspects.
Do you think the inquiry was set up to have this outcome, to protect the Defence Force, and it wasn't about the villagers at all?
I can't speak as to why this inquiry was set up. When we read the terms of reference as to the inquiry, we thought that this was the inquiry we had been seeking in terms of the events of Operation Burnham. We have been, I think it's fair to say, confused and concerned, and now we're at the point where we can't continue to engage in a meaningful way because we're not part of this process. That's how it seems.
Who's been making the arguments for this to be a closed process?
So those arguments have been coming from the New Zealand Defence Force.
You do accept there does need to be this level of secrecy and confidential information, right? It's how much of it could be out in the public.
Yes, so when we're talking about Defence Force information or security information, yes, there can be a starting point that there is information that what we'd say is prima facie, on the face of it, needs some protective measures. However, you know, we've got to be careful not to throw the baby out with the bathwater. It's very important, first of all, to do a stock take of the assertion of material that should be closed and actually see, well, does that all need to be closed? Usually there's a whittling down process because there is a tendency to overclassify material. And then once you get to the core of material that needs protection, arguably, then you look at the measures that may need to be taken in order to protect that. We have spent considerable time looking at how these matters are dealt with in comparable jurisdictions, and Northern Ireland is a very good example because they've had a lot of right to life investigations for civilians who were killed because they were alleged, for example, to be members of the IRA, and so those hearings, those right to life inquiries, are held through the coroner jurisdiction, and our colleagues have told us that no information is withheld. And in that context, the families, there's very clear rulings that the families, the next of kin, have the right to know who was responsible for the deaths of their loved ones, to know their names, and to be there to hear what they have to say.
So if you fail in this High Court judgment, will you just walk away and give up on the tribunal, given it's what you spent years?
Our obligation is to represent our clients' interests, and so we will continue to do that. But I'm glad you asked me that, because there's an important point to also make about the right to life obligation on the New Zealand government and on governments, which is that the right to life investigation should be triggered by the state. It should not be for the victims to be knocking on doors and having doors closed and knocking on new doors over and over again to try and get access to justice. This has been too long and too hard, and this should not be allowed to happen again.
So that's a message to the government, isn't it? You think the government should be stepping in and fixing this?
Absolutely. It's been a very clear message to the government that since August 2010, the New Zealand state had an obligation to conduct a right to life investigation for these families. And then we notified them and asked them to act on it 2 years ago. They failed. We took them to court. We thought they were going to do it. They've failed again.
What could David Parker do? What have you asked him to do, and what do you think he could actually do?
We've asked the Attorney General to make it clear in the terms of reference that a key function of the inquiry is to fulfil New Zealand's right to life obligation towards the villagers who were affected during Operation Burnham. That's all. It's not too much to ask in our view.
Would you like to see any of the families be able to come over and be part of this? Families of victims or the injured people?
In an ideal world, the next of kin of victims would be able to participate in the right to life investigation. What often happens overseas is that there's a audio-visual link, but there certainly needs to be the ability for the families to have meaningful participation in this review and not be asked to wait to the side for a report to come out.
Why do you believe the Attorney General rejected your voice?
We have provided his correspondence, and that's as much as I know.
Do you believe the legal framework is being used to orchestrate some form of a cover-up?
I think that these issues are new for New Zealand. This is New Zealand's first time having to be accountable for civilian deaths during a military operation. So this is our first opportunity to do this. And I've brought along some of the key textbooks that are being written internationally about cases such as this. So we thought this was going to be our opportunity to do this, and that we would be following in the footsteps of other jurisdictions, However, we've taken a very different approach, which we say doesn't meet minimum human rights standards.
What do the authors think of Hit and Run thing and this new legal action?
I don't know what they think of this new legal action, but we know this afternoon the inquiry will be publishing various memoranda and correspondence that have been sent by the non-Crown Core participants outlining their concerns about the process.
How aware of the families about what's going on, and how much contact do you have with them?
So we are in frequent contact with the villagers, bearing in mind, however, that they are in a very remote area. There are security issues in being able to access them because travel through Afghanistan is highly dangerous for anyone. The number of checkpoints and so on. And also there have been logistical issues we've been facing at the moment due to very heavy snowfall. So that is a real challenge for us, logistical challenge. I mean, a case like this would be challenging enough and difficult enough if your clients were living in the same town as you, speaking English. But we have real hurdles here in that regard. Yeah.
Are there structural changes you would like to see that would perhaps make this more worthwhile in terms of there are a lot of people perhaps with vested interest from your perspective in a particular outcome? So what would you actually like to see happen?
There clearly needs to be a procedure that is created by the New Zealand state for automatic right-to-life investigations for civilians killed during any New Zealand Defence Force actions, and that there needs to be a proactive stance taken by the authorities that includes the family's meaningful participation in these proceedings. It needs to be taken out of the New Zealand Defence Force. There needs to be independent civilian oversight of our NZDF and SAS.
How far would you go in saying that this has been set up purely to protect the Defence Force against these allegations, given how long it took for it to get here?
Look, we can't responsibly go into into that territory. What we can say is, to date, we do not consider the inquiry has satisfactorily met New Zealand's right to life obligations. And something I've said previously, and I've said at the hearing, is that the best way that I understand this case, this inquiry, is to keep the focus on the little girl who died during Operation Burnham, because there can be no question that she could have been an enemy combatant or insurgent. So Fatima died during this operation. To date, Fatima's death has never been acknowledged. Her name has never been spoken. So at the present time, we have no confidence that at the end of this inquiry there will be any explanation as to why or how Fatima died.
How long could this delay the inquiry by?
We are ready to go as soon as possible. We don't want this to delay the inquiry. These arguments were heard thoroughly at the end of last year in front of the commissioners. What we are asking is that these are important questions of law, and we consider it as appropriate for the High Court to exercise its supervisory jurisdiction over this important process. All right. Any other questions? So you've got the documents there. We've given you the statement of claim, which sets out the grounds for the review. We have asked for interim orders for the inquiry to not hold any closed or private sessions, taking of evidence, and also the public hearings that have been planned. And so the material there sets out our reasons for that. Okay, thank you very much.